The victim reported that after you faked that you were having car trouble and drove, off onto a dirt road to violate her, after the assault, you began to cry and you said to her, "I'll do whatever you want. I'll rot in hell for this. I don't know what's wrong with me." So that was 1982, and you'd had another sex assault conviction since then. So have you figured out what's wrong with you?
Have you figured out what's wrong with you? A good question. We're going to watch the parole hearing of a man who's a serial offender serving out a 25-year sentence for his second conviction. This case has a lot of information to back it up. It's very unique. He's filed many different appeals, and so we are going to unpack it with all of the details at the end. With that, let's jump in.
Thank you. You're all set. Good afternoon. My name is Officer Saunders. Today is Tuesday, April 30th, 2024, and this is the hearing of the Connecticut Board of Pardons and Paroles. The following board members are present this afternoon, and by stating their names on the record, certified they have reviewed all statutory required documents and available for information and preparation of this hearing.
Good morning, Deborah. Good afternoon, Deborah Smith Palmieri.
Good afternoon, Mike Paul.
Nancy Turner.
Good afternoon.
Please state your name and inmate number for the record.
Lennard T, 97237.
This hearing is being conducted in consideration of the application for Lennard T, 97237. He is serving a total effective sentence of 40 years jail, execution suspended after 25 years, followed by 10 years probation for 3 counts of illegal sexual contact to a victim under the age of 16, sex assault first to a victim under the age of 13, and the after is older than 2 years, and sex assault fourth to a victim under the age of 15 years old. As of today, records reflect a parole eligibility date of February 4th, 2020. There is no victim input in this case. There is an offender accountability plan. It has reviewed and shows the offender has completed individual therapy, anger management, short-term sex treatment, and has maintained employment. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score on the RT falls within the moderate range of risk for recidivism. Utilizing the static 99R, the offender's overall score for sexual offense recidivism falls within the moderate to high range. This is your opportunity to express to the board why you believe you should be granted parole. You may begin.
I'm very sorry, but there's so much of that I did not hear.
So, Mr. Takaline, now is your opportunity to tell us why you think you should be granted parole.
Well, basically, I'm hoping to get parole because I believe if I'm granted parole, I am eligible or I'm going to a halfway house. At this point in my life, everybody is either moved out of state or has passed away. I've lost everything that I had when I came in here. So I really don't want to be dropped in a shelter. I'm 63 years old. It's going to be that much harder for me to get my life back on track.
Mm-hmm. Okay. Anything else?
I missed so much of what was first said. I don't really know.
Yeah. Well,
Can we have that repeated closer to the thing?
Sure. We can have the parole officer repeat her opening statements. She basically she stated on the record what charges she pled guilty to.
Well, I didn't plead guilty to anything.
Oh, you pled under the Orthodox doctrine?
No. I was found guilty in a trial.
Okay, so we're going to repeat the beginning. Right. You're right.
This hearing is being conducted for the parole application for This hearing is being conducted in consideration of the parole application for Lennard T, 97237.
Can you hear her now?
Yes, I can.
He is serving a total effective sentence of 40 years jail, execution suspended after 25 years, followed by 10 years probation, for 3 counts of illegal sexual contact to a victim under the age of 16 years old, sex assault first to a victim under the age of 13 years old, with the actor being older than 2 years, and sex assault fourth to a victim that's under 15 years old. As of today, records reflect a parole eligibility date of February 4th, 2024. There is no victim input in this case. There is an offender accountability plan. It has been reviewed and shows the offender has completed individual therapy, anger management, short-term sex treatment, and has maintained employment. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score on the RT falls within the moderate range of risk for recidivism. Utilizing the static 99R, the offender's overall score for sexual offense recidivism falls within the moderate to high range. And then I had said to you, it is now your opportunity to express to the board why you believe you should be granted parole.
Okay, I understand most all of that, except they said that I was in moderate to high range. And I believe that when I went through the evaluation, I was low. Was that changed?
It's a TPIA of low, moderate, scores of moderate, and the static 99, moderate to high.
Okay, I don't understand what a static 99 is, but when I had completed the courses and when I had the interview with the people in the program, it was, to my understanding, and I believe the paper I was given was I was a low risk recidivism. But I mean, obviously, something must have changed. But
I'm looking at that report right now. No responsibilities for your sexual offense behaviors. And moderate high on the static 99, you scored 4. And that
Okay.
report was prepared August of last year.
okay, I'm sorry, I didn't understand what a 99 static thing was. Was I interviewed for that?
It's part of the assessment that when the connection, the sex offender treatment program came in and did an assessment in
Okay,
terms of treatment for when you're in the community. That
okay,
is part of their assessment.
I do remember that interview with that
Okay.
person,
And then
yes.
when you participated in the treatment program at the facility,
Yes.
they found you to be an average risk for recidivism.
Okay, I was explained I was low, but I mean, it's fine.
Have a reason why he wants parole.
Yes, I mean, he did say why he wanted parole. He needs support in the community. He needs to go to the halfway house. He'd like to go to the halfway house. He doesn't want to live in a shelter. Doesn't want to live in a shelter, and his age.
It would be difficult for me to live in a shelter. I mean, I don't have a serious health issues, but I do have the sleep apnea thing, which I guess I stop breathing in my sleep. So I don't know how a shelter would be set up. I believe you're pushed onto the street every day and then you come back at night to sleep there. I believe that's the way it happened. I don't know that for a fact. I've never been in this situation.
Okay.
I'm just hoping for a halfway house just to help me. I have a job opportunity if released. That's about the only thing I do have going for me. Other than that, I have nothing. No clothes, I have nothing.
Okay. All right. We do understand that you've been incarcerated for a while now and
Yes.
that we've read the report your interview with the parole officer and that you don't have any support from the community at this point, other than you do have employment.
Yes, yes.
Okay. All right. So let us ask you some questions. And at the end, we'll make a determination about parole. And through that questioning, we'll get some more information.
Okay.
All right. Thank you. All right. Mr. Pohl will begin.
Thank you, Madam Chair. So, good afternoon, Mr. Takalani. Is that right?
Good afternoon. Yes, yes.
So just, I didn't hear anything in your statement about, your offenses and, what you've learned or tried to apply so that you wouldn't, offend against any other children. I didn't hear anything about that, so I'm interested in what the situation is with that.
Sir, I was really nervous about this, and I explained to the parole liaison. I'm not guilty. I was never guilty.
So,
In fact,
Thank you. That's, for me, it's like what I'm looking at here, we have access to criminal history.
yes, yes,
So
sir.
it's like, I'm not guilty, I'm not guilty, I'm not guilty, but you have, sexual offenses that go back years, right?
No, sir, I was guilty. The first two offenses that I've committed, I was guilty. I took a plea deal to that, and I'm responsible for those. That was me, absolutely. In this scenario, I've proven it 3 times so far that the crime didn't happen, but I'm still sitting in prison.
Okay. So your end of sentence is June of next year. And certainly, just to ease your mind, because I know you're 63 and such, and that was part of the concern, right? Or probation actually takes a look at things like housing and stuff like that prior to your release, because they have halfway house situations as well. And certainly with your background, you're going to need it, right? Because there's very definitely, you're not going to be able to be around children. And there's going to be, heightened monitoring on everything for you, right? I just, I'm highly concerned that the offenses here, what they are, with the criminal history that has unfolded,
Sure.
that has it today. Yeah.
Sir, the offenses I am guilty of, that was over 45 years ago. And like I said, again, I take full responsibility for that. I did that. That was, but this incident that supposedly happened in 96, which was changed to 95, and then they kept moving the things. Every time I would prove that I didn't commit the crime, they would move the date around. And then now the date is still saying 96, where they know for a fact I wasn't even, I was at a wedding with 150 people for witnesses. So I'm still in court as of today. I still have a habeas pending going forward. I believe something did happen to Melissa. I really, really honestly do. But it wasn't at the hands of me. It was, I believe Weissman did some things to her.
So I can appreciate what you're saying. However, that's not what we have here. That's not what's happened in court and such. So we do have, the sex treatment for private sexual behavior evaluation that the Center for the Treatment for Private Sexual Behavior did. And we have you, taking no responsibility and such. And certainly, as you go out, and you engage in treatment with the Center for the Treatment for Problem Sexual Behavior, I'm certain that they'll help you get to the place where you can resolve some of this stuff with you. So I can appreciate that you were in therapy for a while, that you took anger management, that you completed the short-term sex offender treatment, and that you have employment going back into the community. So that's important. But
I just didn't want to come in here and lie to you. I didn't want to come in here and say, I'm sorry. And I'm still going to court and everything. I just didn't want to do that. I didn't think that was the right thing to do. This whole thing, I've maintained telling the truth. It's never changed.
Okay. And that's, I can appreciate that. Madam Chair, I don't have any further questions.
Thank you. So, Mr. Tuckerline, you took the short-term sex offender treatment program at the facility, correct?
Yes, I did.
Yeah, you finished that just a couple of years ago. Have you ever taken a program like that with your other offenses in the community?
No, there was nothing offered or anything like that back then. There was.
Okay. So have you ever participated in any treatment to address your sex offender offenses?
Well, I mean, what I've done in here, I have taken care of. As far as what I did on prior, I did my probation period and everything like that. And I made up, when I came out of prison back in the 80s, I went straight and narrow. I developed a career. I bought a home. I got married. There was no issues. This incident here, I believe strongly stems from my ex-girlfriend, but that's.
Okay. I did read that. That was part of all the information that we had, that you deny it happened, and it's really, you believe it's her that had put the young person up to it. So you did take the sex offender treatment program. Did you learn anything about yourself in that program, about the way you behave or the way you act, that might help you in the community to not find yourself accused of these types of offenses again? The way you act, the way you behave, is there anything you can pinpoint that would be helpful going forward for yourself?
Honestly, I thought I had learned quite a bit in prison when I came out in 1982. And I learned a lot and how to, I don't know, I never really had, I don't think I had a big anger issue. And my God, I was a service manager at a car dealership. I opened the doors to people screaming at me in the morning.
Yeah, but what I'm talking more about, though, is specifically about the short-term sex offender treatment program that you recently completed.
Right.
And when you took that program, were you able to identify anything that you learned about yourself that would help you going forward to not find yourself in these types of situations again? And you do, as you admitted, you pled guilty to the other offenses.
Yes,
and when we go back and read sort of your version of the offense, they all differ from the victim's version of the offense. So looking at everything all together, what you're before us today, and even reflecting back on those other charges, have you been able to learn anything about yourself?
Yes. In relation to the other incidences, I would not take no for an answer. I would always push the issue to get what I wanted to get. I would misread situations and stuff. And my biggest problem is I would not accept no. If somebody, if somebody got involved in something and started going forward with something and then decided that that wasn't what they wanted, I wasn't going to accept no.
Okay. So how about with the current offense? Is there anything that you've learned about yourself that would help you down the road to not be accused of this type of behavior again? Have there anything you learned about your own behaviors?
It's extremely hard to answer that because, I mean, I thought I was doing the right thing. I was leading a good, productive life. I had an excellent job, a career. I wasn't in any trouble. And I don't know how to answer this because I maintain my innocence. Nothing happened.
Okay, so let's talk. You said yourself, I misread situations. Is there anything that you can take away from the short-term sex offender treatment program that will help you in the future to maybe not read situations inappropriately or incorrectly? You learned anything about your own behaviors and how they're misinterpreted or how you misinterpret situations?
You always learn things as you go through life. For me to pinpoint any one particular thing that I learned, it's hard for me to say. I mean, you evaluate things daily. You may pick up different things through life daily that, would help you lead a better life, a more productive life or something like that. Going forward with my life from here going out, I mean, my sole dedication is to get a job, get employment. I really want to buy a house again. And honestly, I just want to be left alone. I'm not looking for any relationship with anybody.
Okay.
I just, I just, after 20 some odd years of being in here, I just want to get away from everything.
So do you feel like you were able to gain any insight into your behaviors from that program? Because it's other than the anger management program, it's the only program you've done.
That was all they required me to do. I tried to get in.
Yeah, I do understand. So I want to go back to my question though.
Yeah.
Is there any insight you learned about yourself in that program?
Well, during the anger management, they teach you how to deal with anger and stuff. It was ironic when they came to me and asked me to take that program. I was like, I didn't quite understand why. I said, geez, and I said, I was the service manager. I said, I opened the doors, people screaming at me. I said, I thought I dealt really well with anger. I don't feel that I was an angry person or anything like that. As far as relationships, stuff like that, I had a wonderful, wonderful marriage. Me and my wife and I even had a stepdaughter. Everything was fine. Everything was great. I don't know. The program kind of, I don't know. I'm really lost. I don't know what you're looking for.
Okay.
I'm so sorry.
Well, you don't have to be sorry. I was hopeful that you'd be able to kind of pinpoint, some cognitive distortions that maybe you found yourself involved, when this offense was taking place or not taking place. I mean, we're not here to judge guilt or innocence, but we are here to determine suitability for release to the community with the idea of public safety. So
Yes.
When we review your file, this is not your first conviction for a sex offender type offense. And,
Yes.
and as I said earlier, your version of the offenses was always different than the victims. So I was asking, when you took this program, the sex offender treatment program specifically, if you gained any insight to your own behaviors. I mean, obviously your behaviors were taken in a sexual way that was not appropriate for this person. So I'm wondering if you've gained any insight into how your behaviors were viewed that way by the victim, or how you can change your behaviors going forward.
I realize the mistakes. I'm sorry.
No, go ahead.
I realize the mistakes I made in my past, and I really worked hard to not put myself in situations like that. And I thought I did that. And I still kind of believe I did that. There was no victim. This incident never ever took place. So it's hard to, when you ask me a question, have I changed or have I learned anything that would not allow me to get in that situation or anything like that? I was never in that situation. I was never, ever, ever alone with Melissa, ever.
Okay.
So I mean, for me to answer the question that you're answering, for me to answer the question you're asking, I'm just not sure where, I don't understand, I guess. I don't know.
So you were never on a boat with her? You were never alone in the house with her at the lake?
I was never alone with Melissa at any given time. I was on a boat with her and Bonnie. This is a small little 18-foot boat, and we used to go out on the lake fishing. It was Bonnie's niece. Bonnie picked her up and brought her to the house. I never picked her up. I was never alone with the girl. It wasn't my niece.
Okay.
There was no reason for me to ever pick this girl up. And all those incidences that they say happened have been proven not true in court. And what the state has done is, since I proved that was not possible, that didn't happen, they tried to move dates around to make it able to where it was happening. They chose 3 different time periods, and all 3 times I was able to prove with evidence on my side that this was never possible, could never have happened. Even a federal judge ruled that I proved the crime never happened. However, I did not prove I didn't commit the crime, which I never did understand that.
Okay. All right, Mr. Tuckley. Let's see. I think Ms. Turner might have some follow-up for you.
Well, you were found guilty at trial. Was that a jury trial?
Yes, it was. Yes,
So
yes.
a jury of your peers believed the victim who had to take the stand and found her credible. Okay.
Yes.
So I think maybe what would help with the question that my colleague was asking is in the 1982 sexual assault first, the victim reported that after you faked that you were having car trouble and drove, off onto a dirt road to violate her, after the assault, you began to cry and you said to her, "I'll do whatever you want. I'll rot in hell for this. I don't know what's wrong with me." So that was 1982, and you'd had another sex assault conviction since then. So have you figured out what's wrong with you?
The jury found me guilty in this present case. I'm sorry. I know you're getting frustrated.
Well, I'm asking you about, because you're only admitting to the 2 prior. So there were 2 prior sexual offenses.
Yes.
Have you figured out what's wrong with you?
Yeah, I would not take no for an answer. If you went with me, and it was in 82.
The reason I'm struggling with your answer, sir, is because you set these scenarios up in order to victimize these individual women. So I'm not sure that this is just a miscommunication around sexual contact, but that this was you acting in a predatory way to isolate and then violate the victim. And just, so that the sentence you're serving for now is 3 counts of illegal sexual contact. And we have June, August, and September dates in 1996. I know how many weddings you went to, but there were multiple occasions that the victim reported inappropriate contact on your part, and obviously was found to be credible. And that's how you ended up convicted by a jury.
That's correct. But all 3 incidences have been proven not to have happened. Were not able to happen. The September one, I was at a wedding. The prior 2 incidences, I was not in that house. We did not live in that house. That was, and I mean, this case was flipped once before on another habeas. And then it was turned over back on an appeal on technical errors. So I've been in court ever since then, trying to prove my innocence. I've always maintained my innocence on this. What hung me, what the jury believed was my statement. I didn't make a statement. The police officers at the state police barracks wrote the statement. They asked me to come down to straighten this matter out. I went down there. They said it was going to take 20 minutes. I made arrangements for 20 minutes of time to take care of this. And it ended up being almost 8 hours. And they just beat me and beat me and beat me. And then they had me sign the statement. I said, I'm not signing it. I'm not signing it. I didn't write that. I didn't do this. And finally, I said, you know what? Put down on there that I don't know why this is being done to me. And I never touched her, and I'll sign that. And that's what I signed.
Mr. Payne, did you take the stand at the jury trial?
Yes, very limited. My attorney was not very good. He had me take the stand to say that I wasn't living in the house. That was it. Okay. The prosecution got up and
no
said,
more questions, sir. Thank you, Madam Chair.
Yep.
All right. So, Mr. Tokaline, I think, we don't really have any other questions. We typically, we're looking for offender change and what you've learned from the programs. And I think we've sort of parsed out what there is, right? Yeah. So we'll deliberate now about your parole. So, Mr. Cole?
Thank you, Madam Chair. Mr. Tokaline has taken some programs. He has minimal disciplinary report history, having one 8 years ago. He has employment in the community, and he's going to housing, all of which probation can help him with. So I understand his concern to begin with, going out to a shelter, and I don't think probation is going to let that happen.
No.
However, can argue about guilty or not guilty. That's not that's not really what I'm concerned about. What I'm concerned about is that we have sexual offenses here, and we have criminal history sexual offenses, and I just don't. I don't see how I can allow Mr. Tokaline to go out on parole prior to his sentence.
Okay.
It's his criminal history, and it's the nature and circumstances of the current offense that really have me concerned.
Okay. Yeah. Ms. Turner, anything to add?
Inadequate evidence of offender change.
Okay. I agree. I think Mr. Tokaline he presents a risk to the community to be out early on discretionary parole with what we have before us. So in the matter of Lennard Tokaline, inmate number 097237, There's a motion to deny parole for the following reasons: nature and circumstance of the offense, criminal history, and inadequate evidence of offender change. Do I have a second? All those in favor?
Aye.
Aye. All right, Mr. Toccolini, we were unable to vote you to parole today. Probation will help you though with some housing as you get closer to being back in the community.
I hope that's correct, but I was told that's not. I was told by the people here that when you discharge, they just drop you on the street.
Well, you're on the sex offender registry for the rest of your life, so that adds some level of concern for your risk to reoffend. So you'll have some clear oversight.
I believe
Yes.
that's for 10 years.
If we have lifetime.
That might have been changed too then.
Yeah, well, that's what our records, but you do between now and your end of sentence, you might want to think about how you can manage housing in the community, give you some time and some resources to work with. All right, so best of luck to you, Mr. Toccolini. Thank you.
Thank you. Thank you for your time.
This concludes the hearing for 9/7/237.
Cockroach, just a classic cockroach. He's sitting there nearly 25 years of his sentence, and he's done one program. Not that I'm happy he didn't, because had he done a program, he would have been able to have said exactly what the board wanted him to hear, and they probably would have been like, great, go on your parole. Now he's getting out anyways, regardless, in like a second. Now he is insisting on his innocence, and man, we have a lot of information on this case. Thank you, Richard. I mean, more so than we've ever had, especially for a case like this. It's unique, and that's because he's really been fighting this for the past 25 years. And there's quite a lot of information that we'll go through. We'll go into the details. I actually had a hard time understanding it because there was so much and it's kind of convoluted. So I was going back and forth with Richard as he was explaining it to me in writing. But first, I just want to take a little bit off of venting about this hearing, which was like, he's like, I would not take no for an answer. I misread situations. Keep in mind, we're talking about little girls, like 11-year-old, like these are the ages of his victims. I misread the situation. And it's just insane. But, it's nothing new. We've seen so much of this. We're not really surprised. I figured if there's any like karma to it, it's that he has no support. No one's there for him. He's getting out with nothing, not even just the shirt on his back, whatever prison shirt they give him. And, he thinks that he's going to go and buy a house. Maybe, he's been locked out so long, he doesn't know what's happened to the economy. Unless, of course, if he has like a bunch of savings, who knows? But the, okay, I'll give you like a briefing first for, like from what Richard had kind of unpacked for me. And then I'll go through the actual details. I'll read from the court transcript of how he was caught. It's not a simple case. And actually, a judge let him out twice on bond. Judges actually left and right let this guy off. I'll get into it. So in 1982, he was convicted of his first offense of the little girl, a different girl, right? He was sentenced, of course, to just 5 years, paroled after serving only 2 years, because he's just a child, right? And after he was released, he sexually assaulted another girl. This is 1996. So it jumped. I guess, he went, what is that, like 12 years before getting caught again. And it wasn't simple. He didn't just get caught with this right away. It was actually a complex process, which we'll get into. He had the trial in 1999, a jury trial. He was found guilty and sentenced to 40 years, suspended after 25, with 10 years special parole probation. However, he immediately filed an appeal, and the judge agreed and gave him a $250,000 bond, which he paid, and was then released until he lost his appeal in 7/13/2001. But that wasn't the end of it. He filed an appeal again in 2002 and secured, and he was able to get out on that. Now, while he was out on bond, he's living in the home with his fiance or his wife, and her daughter, which is, you know, scary to think that that could even happen. And law enforcement officers found a CP website. And this was back in the day. Remember, this is in the early 2000s, 2001, 2002, 2003, when this is all happening. And they find a website that is selling CP using like credit cards. So they get a warrant to get into this website servers, which is like in California. And lo and behold, whose name pops up? Yes, our dear friend Lenny. So, give the law enforcement officers credit. They say, we're going to bust this guy. So, Lenny happened to be selling his house at the time, and the law enforcement officers pretended to be real estate agent, went into the house, saw that he was that the computers were there, and they got enough evidence to then get a search warrant, which they used to get on his computers and verify that indeed Lenny was registered to this site, CP, using it on a regular basis for multiple years while he was out on bond. So then you might ask, well, why wasn't this brought up in any of his charges? And like, this should have been it, right? No, because it's Connecticut, right? A judge actually said that because the website's servers were taken down, that there was no proof that he had been downloading CP and that the warrant was ill-gotten in so many. I know it sounds crazy. It's hard to believe. Now, if you want to play devil's advocate, you can say, well, the judge probably never used a computer in his life. He had no idea what he was talking about. But, you know, Richard's theory is that the judge is probably a card-carrying member of NAMBLA, North American Man-Boy Love Association, who's headquartered in Boston. So I think that that's probably likely, because who the hell takes the side of a two-time sex offender who's out on bond for sexually assaulting a child? Who the hell, you know, you just can't make it up. You can't make it up. So it was all thrown out, all that hard work, all that investigative genius by law enforcement, and the judge just threw it all out. So there you go. Now let's go to, there's so much information here, it's going to be, but let's go into the details of this and as to why, you know, there's, I'll have to figure out how to really do this. You know, for those of you who want to go to 2x speed, I forgive you. I do that myself. All right. So I think this is his first writ of habeas corpus that he filed. And when you read these, they actually do say that his attorney failed him in many ways, and that's why he was granted. But, you know, ultimately he loses the appeal. So it's interesting to hear that. But the following facts, lengthy procedural history, are relevant to our resolution of the petition of appeal. In 1999, following a jury trial, the petitioner was convicted of sexual assault of first degree in violation of general statute. And that's when he was given the 40-year sentence of imprisonment, executed after 25 with 10 years probation. In 2001, he appealed from his conviction, and our Supreme Court set forth the details and the facts underlying his conviction. It explained that the petitioner, a 35-year-old man, had engaged in 3 acts of sexual contact with MC, the 12-year-old victim. No, but you got to understand, he just misread the situation. you know? After MC told her mother about the sexual contact, the petitioner gave an incriminating statement to the police, which was read to the jury at trial. In the statement, the petitioner claimed that MC never objected to the contact and that the contact did not constitute sexual intercourse. You know? Because he just didn't take no for an answer. He would misread situations. Our Supreme Court affirmed the petitioner's conviction because the claims were not reviewable, but noted that the jury was presented with significant evidence aside from the victim's testimony that the sexual abuse had in fact occurred. For example, MC's physician testified that a physical examination revealed that MC had experienced vaginal penetration, which most likely was caused through sexual relations. But most importantly, the petitioner's own written statement corroborated much of what MC claimed to have occurred. Emphasis added. I like how they say that. In 2002, the petitioner filed his first petition for writ of habeas corpus. He was represented by attorney Conrad Ose Seifert in both his first habeas trial and his subsequent habeas appeal. His amended first petition alleged 1, 11 counts of ineffective assistance by his trial counsel, attorney Mark Hasselab, ineffective assistance of his direct appellate counsel, attorney, factual innocence following his habeas trial. But I want to, and it says in 2012 he filed his, I want to go to the facts of the crime, of how it all came about. Hold on, let me do. Okay, here there's like 8 documents on this. So we're going to go through what the jury saw. So on the basis of evidence presented to the jury, reasonably could have found the following facts: the victim, MC, born in 84. In 1996, the defendant, who was 35 years old, was the boyfriend of the victim's aunt. The defendant and the victim's aunt lived together in a house near a lake, and I doubt she had any idea that he was a sex offender, because they probably didn't, I don't know if they had the registry yet. Yeah, I don't think it came from a quick Google search. It looks like it didn't start until 1997. So, the defendant and the victim's aunt lived together in a house near a lake where MC sometimes visited. Usually, the defendant went to MC's house to pick her up and bring her to her aunt's house during the visits. MC and the defendant often played video games or went fishing together. Which could be the first red flags, right? But people maybe were a little more innocent back then, huh? 3 acts of sexual contact by the defendant occurred during the period from June 1996 through September 1996, when MC was 12 years old. In the first incident, the defendant kissed MC's private areas. In the second incident, which occurred in August 96, when the defendant and MC were fishing from a boat on the lake, the defendant placed MC's hand on his thing, and then he put his hand over hers and manually stimulated himself. During the third incident, which occurred in September 96, the defendant invited MC to come to his bed. He then got on top of her, pinned her hands above her head, and penetrated her. MC did not tell her mom, and this is where so this is how they find out. MC did not tell her mom or aunt about the events with the defendant because she was afraid of the defendant. In October of 96, MC and her family moved to another state. So he probably thought, man, I got away with it. Now, in February of 1998, so this is 2 years plus later, while cleaning MC's bedroom, her mother found a letter written to MC from a man named W, who was a friend of MC's family. I don't know why he's a man, not a child, right? So a man named W, who was a friend of MC's family. W had begun to babysit for MC and her siblings in the summer of 97. I mean, it seems they just keep surrounding themselves by. Okay, let's finish it. At that time, W was 32 years old and MC was 13. In the letter, W told MC that he wanted to hold her and take her pain away. Yep, another roach. It's like, crazy that this poor girl is surrounded by roaches. It's like, how does that happen? I guess when you have adult men babysitting your, I don't know. Anyways, MC's mother was concerned about the contents of the letter and confronted W about his relationship with MC. Her mother also confronted MC about her relationship with W. Although she denied any sexual contact with W, MC told her mother about the incidents that had occurred with the defendant. So it's at this time, 2 years later, when she's confronted about this other roach, that she says, no, nothing happened, but something did happen with this roach. During the summer of 96, MC also had told W about the defendant's conduct prior to disclosing the information to her mother. So she had told W about it. So there's like another, it's another reference point that you didn't just make it up, right? Like, well, you have a Roach's testimony, but okay. The defendant gave a statement to the police in which he responded to MC's allegation of sexual abuse. In the statement, the defendant claimed that he and MC often horseplayed together. The defendant admitted that he may have had sexual contact with MC during this horseplay, although he claimed MC never objected to such contact. She never objected to it, right? It's just horseplay. It's not the first time we've heard that from a roach. And that the contact did not constitute intercourse. The statement was entered into evidence and read aloud to the jury, and this is part of his appeal. And it's so funny listening to him adamantly say, I didn't confess. The police made me say it. I didn't want to say it. I just did it. And it's actually quite interesting because had he just lawyered up right away, maybe he would not have been found guilty. I don't know if the confession, it seems that or if he would have won the appeal, because they're basically saying that the appeal was withheld because of his confession more than anything else. In the appeal, they agree that he had bad counsel, but that his confession was enough. On appeal, the sole issue is whether under Golding or the plain error of doctrine, the defendant may prevail on his unpreserved claim regarding the omission of certain expert testimony because we did not consider the defendant's claim to be either constitutional in nature or constitutional plain error. We affirm the judgments of conviction. So Elton Grundon, a licensed clinical social worker at a counseling and mental health center in the state of which I do love that the whole, at this time in the early 2000s that they took her claim seriously. Like we just don't see that like ever. In Louisiana, they were just giving him a plea deal of a few years, but here they went to trial. They took it seriously, but then it was like the judges that just kept letting him out over and over and over again. And we'll go through how he got out of that CP thing. It's just crazy. So he had met with MC in February 1998 to discuss her allegations of abuse by the defendant. Grundon testified that in the meeting, MC had described instances of sexual contact. Defendant had also stated that his opinion that the victim had suffered abuse of a sexual nature perpetrated by the defendant. Finally, Grundon testified that it is his opinion that MC's testimony was truthful based in part on the consistency of her accusations. The defendant did not object to any of Grundon's testimony. Nevertheless, the trial court did issue consistency of accusation instruction to the jury regarding Grundon's testimony on direct examination. Okay. All right, so now we'll read his actual statement. At the trial, W admitted that he and MC had kissed on occasions. This is W, right? The other Roach. Although both denied that they had engaged in any sexual relations. W was investigated by local police and family service units, but no charges were brought against him. Why were no charges brought against him? I guess because they wanted him to testify against this Roach. And, to be fair, if you have one Roach acting as a witness against another Roach, I would argue that a good attorney should have been able to cause enough doubt in the case, right? I mean, remember, it's two Roaches testifying. Like, he's claiming, "Oh, I didn't do anything. It was that guy." So, I mean, to this Roach's point, but the judges did finds that he had bad representation, but his confession is what pinned him to being guilty. But it is a pretty ridiculous situation if you think about it. The defendant's statement provided in relevant part on one occasion when MC was over, she and I had been horseplaying. Now this is the defendant. I recall that MC usually had worn either a halter top and shorts or a bathing suit, or usually some other summer attire. During our horsing around, I recall that I moved her t-shirt up, exposing her midsection, put my mouth on her skin, and blew onto her skin, causing a fart-like noise. I may have put my mouth on her in the area of her breast, and if I hit any part of her breast, it was by accident. MC had just begun to develop her. Okay. And my mouth never touched. Okay. During the time when MC and I were horsing around on the boat, I may have had an erection. Remember, he was never alone on the boat. MC may have grabbed it by accident. When she may have grabbed it, she didn't make a big deal about it. I never asked MC to grab it. MC grabbed it. She didn't make a big deal about it. I never mentioned the incident to anyone. On one occasion, I recall being on my bed in the bedroom during our horsing around. I ended up on top of her on the bed sometime during our horsing around. Remember, how old is she? 12? 11, 12? I mean, it's just... cockroach. I guess it would be... Yeah, 12. 12. He's 35. So it's just like, hello. And just remember, for any of you who are saying, well, maybe he didn't actually do it. Maybe it really would. Just remember, when he was out on bond, they got him on all that CP stuff. Just keep that in mind. And remember, this is his second offense after what he had done to an 11-year-old. So I don't trust him for a second. Although it is a pretty insane situation that there's one Roach pointing a finger at another Roach, and that Roach wasn't prosecuted. I recall having her arms pinned above her head, holding her down. This is his confession. I was on top of her for just a couple minutes, and as I was on top of her, she was moving around trying to get away. While she was trying to get away, her clothes were moving around. During the time I was on top of her, when we were horsing around, it's possible that I became excited and got an erection, because in the position that I was in on top of her, she would have felt my... Okay. It's nasty. Due to the fact that we were both moving around, she may have misunderstood that. This is his confession, man. MC experience, okay. There's also his testimony concerning depression and change in character MC experienced during and after the summer of '96. More specifically, MC's aunt testified that after the incident on the boat, MC returned to the house and appeared withdrawn and quiet, which was out of character for MC. Most importantly, the defendant's own written statement corroborated much of what MC claimed to have occurred. See footnote 7 of the opinion. The Court shall not be bound to consider claims unless it is consistently claims unless it is distinctive raised at the trial or arose subsequent trial. The court may, of interest to justice, notice plain error not brought by attention to trial court. So I think that paints a picture of what happened. Now let me go and share with you the whole CP thing. Okay, so this is the CP case that we're going to talk about that I briefed you on earlier, and it's quite interesting in the sense that a judge actually agreed with him on this case, and that's why they don't mention it. But while he was out on bond because of his appeal, seemed to have been granted before it went to the Supreme Court in Connecticut, detectives found him involved in this CP thing. So we're going to read about how that went down. And remember, this is while he's on bond. So by way of background, on April 23rd, 2003, members of the Connecticut State Police Computer Crimes and Electronic Evidence Unit, CCEE, you all call them supermen and women, executed a search warrant upon the defendant's residence in Ashford, Connecticut, as part of an ongoing CP investigation. So this guy's out on bond facing, 40-year sentence or whatever, and he can't help himself. And good for the detectives. Now, the warrant sought permission to search the defendant's residence for evidence of CP in the form of electronic communication from email accounts that pertain to the purchase of production, promotion, or dissemination of CP. Dissemination. Evidence of electronic communication of the website SiteKey or USA Lolita, and any credit card information, notation of any passwords that may control access and evidence of CP, its purchase, production, importation, promotion, or dissemination by mail or by computer visual depictions, other material or property that depicts CP devices use creative view, stored visual, blah, 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 blah. Pursuant to the warrant, CCEEU, the Superman and woman, sees various computer components, computer accessories, film, and paperwork from the defendant's home. During the course of the search, these Superman and woman discovered a small amount of Mary J. and a pipe in one of the defendant's bedroom dresser drawers. Based on the discovery, the defendant was arrested and charged with a violation of general statute, which is awesome that that's what they arrested him on. So this guy's out trying to sell his house and they arrest him on that, which is just, again, great. Now, to date, however, the defendant has not been charged with any criminal violations arising out of the seizure of the other items, which were subject matter of the search warrant. So, in the absence of showing that the information contained in the warrant are false or misleading, or that the material omissions of the affidavit, a hearing a motion to suppress is limited to review of the four corners of the affidavit, thus the relevant facts referred to in the affidavit and upon which the judge relied to find probable cause of putting the issuance of the search warrant are as follows. So now they're talking about how they ever got that search warrant to even find the stuff. So on April 20th, 2001, a police detective in Ohio filed a complaint with the National Center for Missing Exploited Children, NCMEC, after he discovered a website containing CP. The NCMEC traced this site to location in Dallas, Texas, and notified the Dallas Internet Crimes Against Child Task Force, ICAC. Thereafter, on or about April 24, 2001, a detective at the ICAC embarked on an undercover investigation. And to me, this is fascinating that in 2001 they were doing this. It feels like, it almost feels like we've gone backwards in the past 20 years. They were doing this in 2001. So what are they doing now? And now we have like YouTube sleuths that are doing this, not, but anyways, okay. By using an adult credit card verification service located in Santa Clara, California, SiteKey, the detectives were able to access the suspected website and download from it graphic images of CP and explicit. Okay. During the course of the investigation and by using the same process, the detective also uncovered 13 additional websites containing CP. So in this process, they now found 13 other websites. In February of 2002, a search warrant was issued by a Texas magistrate and executed on the premises of SiteKey in Santa Clara, California. The search yielded a database containing the names of several thousand customers through the United States who used the service to purchase CP. So these brilliant roaches are using credit cards to purchase CP from websites, which, back in the early 2000s, they probably did not understand how screwed they were. In November of 2002, the defendant's name and information gleaned from the database was forwarded to CCEEU. So our Roach Prince shows up in that database, along with over 100 other names in Connecticut. I wonder how many judges were in there. The database information revealed that in May of June 2001, 2 different credit cards traced to the defendant were used to purchase access to the website. Okay, so they tracked his, not just that, not only was it his credit cards, but they had his name, they had his phone number, they had everything connected to him. Now, they go to this. On February 2nd, 2003, CCEU conducted a criminal history check, which revealed that the defendant had 2 first-degree sexual assault convictions and was a registered sex offender. Further, investigation revealed that the defendant was incarcerated for over 2 years in the early 90s for his first conviction, and he was reincarcerated on July 13, 2001 after losing the appeal of his second conviction. So he lost the appeal, was reincarcerated, but the defendant was again released on September 24, 2002, pending a new trial after his habeas petition was granted. Now, it's interesting. It says here the defendant is not a registered sex offender in Connecticut or any other state. No requirement exists for such registration since his 1999 conviction. So I don't know. I guess we could check out that footnote. But on April 16, 2003, detectives in the CCEEU posing. Now, this is really cool how they got him, right? So they find out that he's selling his house. So they pose as potential buyers. They met with the real estate agent to take a tour of his home. So they get into his home, which was for sale, right? So he's out on bond. He's trying to sell his home. The real estate agents informed the detectives that the defendant was living at the home with his wife and daughter. And I don't think this is biological daughter. And think about how disturbing that is, right? He talked about his stepdaughter. Scary. At the residence, the detective observed a computer in the master bedroom. They also observed pictures of the defendant and male clothes in the bedroom. In the affidavit, the affiants also discussed methods of transmitting CP via computer, methods for hiding such information, and police methods required to retrieve such information, both on their experience and training. The affiants also averred that persons involved in sending or receiving CP tend to retain it for long periods of time. Based on this evidence, the issuing. So I'm confused, but did they discuss these methods with him? I think that's what happened. I think they brought it up, and just knowing he would say something, I think the way I understand it. They're like, hey man, CP, blah, blah. So based on that, the issuing judge found probable cause to believe that the evidence gathered in the defendant's home, including computer systems, correspondence, and video devices, would contain evidence that the defendant participated in commission of the offense, possessing CP. Now, he won this appeal somehow from the card-carrying judge. He points out that there's no allegation in the affidavit that the defendant downloaded any illegal CP. The defendant argues that without allegation that the site offered illegal CP, that the defendant downloaded illegal CP. Can you imagine a judge taking the side of someone who's a second-time offender that is out on bond for this current offense and has his credit cards and everything tied to it, still finds a way to believe him? So let's see. The court troubled by the issue of probable cause. As the court stated, the warrant contains no facts that issuing judge to reasonably infer that the defendant downloaded or ordered any material from the Texas website that was seized in December 1999. This is the judge taking his side. Really? 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 Bro. Really? Imagine. While there are sufficient facts set forth to infer that the defendant placed an order for CP in June 2000 from an undercover website, the warrant also alleges that the defendant canceled the order. There are no facts from which the issuing judge could infer that the defendant actually received CP from the website operated by the state police. Ultimately, the court denied the defendant's motion to suppress. The denial, however, was based solely on the fact that in addition to alleging violation of general statute, the application also alleged that the evidence constituted a violation of attempted possession of CP. No such allegation of attempted possession of illegal CP in violation of general statute was made in the present application. And this seems like just a huge error, right? They should have just included that charge of attempted possession. While the state argues that the probable cause determination should not be limited to specific statutes set forth in the warrant, it cites no authority to support this assertion. As such, the court rejects the state's argument that issuing judge could have drawn inferences supporting a finding the defendant had committed the offense of attempted possession. With respect to the issuing judge's finding the probable cause that the defendant committed offensive possession of CP, the court determined the evidence that the defendant had merely subscribed to a website which contained CP was insufficient to permit magistrate to make a determination that evidence of CP would be found on the defendant's home. That is insane. A two-time convicted child Roach, out on bond, subscribed to a website for one purpose only, to sell CP, where he has his credit card, and the judge is saying there's no proof that he actually bought or downloaded the CP, only that he subscribed to it. That's insane. That's insane. You can't come to that conclusion. As the court stated, the affidavit contains nothing concrete to suggest the defendant had transmitted or received images of CP. The court found that in context of this case, finding a probable cause would not be reasonable. If the government is correct in its position, then probable cause existed to intrude in the homes of some 3,400 or even 6,000 individuals merely because their email addresses were entered into the Candyman website, which contained illegal CP. Yeah. What's wrong with that? Dude, if we needed any proof that this judge was trying to protect people he knew, maybe even himself, I'm sorry, but can this be? Do we need any more clear evidence? I'm not a conspiracy theory guy, but let's be real. He is making a ruling to say that this whole thing should be thrown out because how could it be merely proof that he signed up for this website? If that's the case, then 6,000 people will be guilty. It's like, yeah, they are, because there are more than 6,000 roaches in America. Like, what do you expect? What even statement is that? Wow, wouldn't believe it if you didn't see it. Here you go. This is why we do this. This is why we do this. Thank you, Richard, for making sure all of this was in here. Without any indication that any of these individuals downloaded or uploaded or transmitted or received images of CP, without any evidence that these individuals did anything more than simply subscribe. This is not judge, right? Well, all they did was subscribe to the website. The government argues that it had a right to enter their homes, to conduct and search, to seize their computer files, equipment, scanners, digital cameras. This cannot be what the Fourth Amendment contemplated. Now, I think the Fourth Amendment would have done everything to protect our children. The context here is the internet, specifically the use of the internet, the trade of CP. Law enforcement needs a certain amount of latitude to address those who would violate. Okay, so this is now actually, I think, talking on our side, right? The context here is the internet, specifically the use of the internet to trade CP. Law enforcement needs a certain amount of latitude to address those who would violate the CP laws and exploit or abuse children, just as there is no higher standard of probable cause when First Amendment values are implicated. However, there is no lower standard when the crimes are repugnant and the suspects frustratingly difficult to detect. The state attempts to distinguish Perez, arguing the affidavit contained evidence beyond mere membership or subscription. Specifically, the state argues that the evidence of the defendant's use of the credit card was psyche, the disclosure of his email account, the description of USA Lolita as a collection of the best Lolitas, and the defendant's prior sexual assault convictions were sufficient for the magistrate to infer that the defendant subscribed to the website in order to possess CP. No freaking duh. The state further argues that the use of the term Lolita in the website domain name lends credence to the conclusion. That's a good argument. It's quite obvious. That's quite clear. There's no, like, hello. Now, while the failures to allege that the defendant actually blah, 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 downloaded CP material from the website to his computer hard drive may not in itself render the warrant defective. The affidavit must preserve a substantial factual basis for the magistrate's conclusion that probable cause existed rather than mere suspicion. I'm going to blow a gasket. The court affirmed finding probable cause based on an affidavit that alleged that the defendant subscribed to the website known for CP. Importantly, that the affidavit explained how the viewer of the website must direct the computer several times to proceed. In the face of warning and statements, and hardcore images of CP would be received. The viewer must also select a payment plan, which promises to provide access to varying degrees of CP. The defendant uses credit card to purchase the platinum plan. He purchased the platinum plan. You can't make it up. Which promised the greatest access to CP and entitled him to download the browser, which would have enabled him to view the images. Further, the affidavit explained how platinum plan members would be enabled to download zip files, which required an additional step to unzip and view the images. On such members' computer hard drive requiring significant amount of storage space, which was likely to be found only on a computer in a member's home. Finally, the affidavit referred to the defendant had made 3 consecutive monthly payments. He made 3 monthly payments for his platinum subscription for access to the website, which entitled him to receive the CP. Based on the totality of the evidence, the court affirmed the findings of probable cause and denied the defendant's motion to suppress, as the court defendant actions in making 3 consecutive monthly payments for the platinum plan subscription for access to the website are consistent with the conclusion that a probable defendant thereafter assessment internet proceeded to download images. So then what happened? Where did this go wrong? Man, it's a lot of information. By the way, I'm only sharing some of it. There's like 5 appeals, and I've been actually recording this. I did 30 minutes of recording without clicking the record button. So I've been at this for a while. I had to start all over, and that was frustrating when I looked up and I'm like, oh my gosh, I'm not recording. He would have been entitled to receive the quarterly CD containing CP as advertised in the notice. You can't make this stuff up. Yeah. He was going to get a CD. Unlike the rich factual descriptions set forth in the affidavit incident case is plagued with paucity. Most compelling admission in the affidavit is that it is devoid of evidence, and the website even contain images of CP. So is this where it goes wrong? The state concedes in its memorandum that admittedly within the 4 corners of the affidavit, there is no allegation that the site is a CP website or even the website. Where are they? I don't know. Thus, the only nexus between the website and the defendant was alleged to have entered in the site as illegal sites, as the affidavit. I don't get why they didn't just scan the computers and get the info. Was it like, did they and it wasn't allowed as evidence? I don't understand. Okay, let me jump ahead and see what happens here. I'm jumping to the end, the conclusion. In conclusion, the affidavit failed to present a substantial factual basis for the magistrate's conclusion that probable cause existed for the crime of possessing CP, and the affidavit for a search warrant is defective. Evidence obtained as a result of the subsequent search must be suppressed. So it could be they did search the computers, they did find it, but because of this ruling, they can't, it's suppressed. Accordingly, the defendant's motion to suppress all contraband and pornographic images obtained as a result of the search and seizure warrant authorized on April 17, 2003 is granted. Yep. Yeah, they definitely found the imagine being this detective group doing this incredible job in the early 2000s, figuring this all out, busting this Roach, and having a judge throw it out. The matter shall be set down for a hearing determination regarding the return of the defendant's property. And then he gets his property back with the CP in it. You can't make this stuff up. You can't make it up. You can't make it up. And this is why we do this, because it is clear to anyone with common sense that I don't think it can get more clear that the picture is painted. The die is that there is a Roach that is on bond for his second offense. They find 3 months he played for platinum service. They also set up a sting where he gave a money order to buy stuff, but he canceled the money order. And the 3 months platinum service was no proof. So the warrant was invalid. It's like, and the judge is saying just because of the email address, and then we'd have to arrest 6,000 people. And it's like, really? Like, does it take that much of a leap of faith to assume that the judge is nervous for himself or someone he knows? It's just my assumption. It's just my guess. You almost forget about the initial Roach that we just saw here, who will be getting out next year, give or take a few months. And, I doubt he'll be able to control himself. And hopefully the good old detectives that got him locked up to begin with, hopefully they'll be watching him and they'll get him back in there. But you wouldn't believe it if you didn't see it. And again, this is why we do this. For me, this was incredible to see, just incredible. And thank you, Richard, for putting it all together. Thank you all for being here. And with that, I'll let you go.